Candice Haley. I'm a probate and estate planning attorney. And so my main areas are I help you draft your wills and all of yours. I help you prepare for death and while you're living in case you become incapacitated, meaning you lose your mind and you can't make your own decisions. And then I also help once you, louder. Then I also help once you do pass away, I help your heirs kind of get your assets together. And if there's any contesting or any fighting, I help kind of resolve that as well. So I'll kind of start with the before death and before you incapacitated and preparing for that. So those are things like your will, a trust if you need it, and then a power of attorney and a medical power of attorney and a directive to physician. So the directive to physician is an advance directive what the judge was just discussing. And that's pretty much telling your physician that either you want to die comfortably without food or water, or you want to have food and water if there's nothing else that they can do. And your illness is literally they've done all that they can do. So do you want food and water, or do you want to just die naturally? So you're telling your physician that so that your family doesn't have to make that hard decision for you. Because a lot of times people start fighting over, no, mom wanted food and water, and maybe she'll come back, or maybe, you know, so that helps your family. A lot of these documents just kind of create, it prevents a lot of fighting. That's what they really do. And it also helps to tell people what your wishes are if you cannot do it at that time. So that's a directive to physician, which is also considered a living will a lot of the time. What I want to happen to me while I'm living, food or water, or no food or water when nothing else can be done. Then you have what's called a medical power of attorney, and that's different because this person, a medical power of attorney is, you're telling a person, you have permission to make my medical decisions for me when I cannot. So that's if, let's say you're at the hospital and you are just you're on life support, and someone comes in and says, or your children come in and say, mom wanted to be pulled off life support. Well, if someone else has a medical power of attorney, they get to make that decision, not you. So it's important to have that because some of your children may know your wishes and some may not. And then that can prevent the fighting and things like that as well. And you want someone that you trust to be able to make those medical decisions for you. So that's what a medical power of attorney is. And then you have what's called a durable power of attorney. And this is for your non-medical things. These are all things like financial, anything that's kind of transactional. This other power of attorney can do. You're giving a person permission to act on your behalf when you cannot. So that's what an agent, a power of attorney is, just an agent for you that represents you when you can't make your decisions. Now the medical power of attorney that we talked about that make your medical decisions, that is effective once you cannot make your decisions for yourself. But and then you have your regular power of attorney, that's the transactional, that's everything non-medical. That becomes effective either, you can have it effective immediately, and you can kind of limit it if you would like to, make it a little creative if there's some things you want them to take care of and limit their powers, you can do that as well. Or you can give them, there's a plethora of powers you can give them as well. So it just depends on what you want. But it either becomes effective immediately if you want it to, or becomes effective when you cannot make your own decisions and a doctor has determined you cannot make your own decisions. That's probably what you want if you're still in your right mind. You want to be able to still make your own decisions. But it is void upon your death. It doesn't matter if the person who's your agent, so let's say I have a daughter and I appoint her as my power of attorney. She has to be above the age of 18 to make those decisions for me. And then once let's say I die tomorrow at 10 o'clock a.m. If she uses her power of attorney at 10:01, it's void. Whatever she's done is void and has to be undone. Because whether she had noticed that I died or not, that action is no longer effective because the power of attorney expires immediately upon death. So you can't use it to say, oh, well, I was mom's power of attorney before she died, so I get to make her decisions to her about her estate when she dies. So that is no longer valid. So just keep that in mind as well. And then, so that's the durable power of attorney for your transactional. You have your medical power of attorney for your medical needs. And then you have the directive to physician, which is also called a living will. And that's the food and water and, to let me die comfortably. Then you have a will. Now, a will, pretty much what that does is it tells, I guess, the world who you want to get what when you die and who you want to be your executor. And it's important to name it an executor, which is a person, you can almost think of it like your agent for you when you die. They get to speak for you and stand in your shoes after you die and get to do pretty much the exact same things you will be able to do upon your death. And it's important to appoint somebody who's qualified, so they cannot have any felonies or have committed any crimes of what's called moral turpitude, which are like dishonest crimes like solicitation, prostitution, and theft, and things like that. If they've done that, they won't qualify. And then you want to make sure that it's a person that you trust to do that, because this person is going to be acting as a fiduciary, which means they're going to be owed money, they're going to be in a position that they're going to be trusted to do certain things on behalf of others. So it's important to put someone there that you do trust and that you believe would honor your wishes in that will. And so in this will, again, you name the people who you want to give what, and you name the assets that you want them to give. And so the will is not effective until, one, a person is deceased, and you actually take it to probate court. Until you go to probate court, that will, you cannot act on that will. So let's say, who died recently? Well, actually somebody, I think it was okay, it wasn't her, it was somebody else who died without a will. Okay.
Prince died. Didn't have a will.
Okay, there you go. And there's still a lot of fighting in the state right now. Yeah. And so a lot of times, if he had a will, you cannot operate. You cannot. Let's say that he had a bank account, and let's say he did have a will, and somebody said, "Well, I'm his child, or I'm supposed to be getting something, inheriting something from him, and so I'm going to go to the bank and try to get the money from the account because I'm listed in the will." Well, unless you have actually taken it to the courts and probate. So probate means that we're pretty much asking that judge of that probate court, hey, tell us this will is valid and allow us to prove that this person has actually passed away, and then allow us to start operating under what that will says, okay? And it's, in theory, it's that simple, but there's more to it. It's the application, and you got to get signatures, and the applicant has to be qualified and all of that. And then you actually have to prove that this person is deceased, and through testimony in actual court. So once you do put on the testimony, you provide the will, and the court says this is a valid will, and nobody has contested it. Nobody has contested it. The court will issue what's called letters of testamentary. These letters are just authorized by the court. They have their stamp, and they list the person who's the executor named in the will to say that these people have the right to go and demand money from people. You can go and sue people. You can get all of the assets. You can retrieve them and either keep them and safeguard them, and then pay the debts, and pay, give whoever the beneficiaries are and give them what they're owed. So that's what those letters give you. So you can't just go to the bank and you just have a will in hand and say, give me the money. They're not going to give you that. They're going to say, hey, you need to go to probate court and come back and give us these letters testamentary. And that gives you the authority to then act on behalf of the estate.
But a PLD will override the will,
So,
right? Or no?
yes, no, I actually was going to get to that.
Okay.
Thank you so much. So a lot of times what can avoid the probate process is if you have what's called a POD, which is a payable upon death account. And that means that it acts like an insurance policy. You have an automatic beneficiary, and it'll pass to the person that you name. But be careful, because in the state of Texas, we're a community property state. So there may be times where you think, oh, it's my bank account, and I name my child that was now a part of my marriage as the beneficiary. Well, your spouse that's living has a right to 50% of that account if it was not separate property or things like that. So technically, you can have a beneficiary with a payable on death account, but you have to be careful because you're not just entitled to that whole 100% if you're in Texas and you're married, because any of that money was acquired during your marriage. So just be mindful of those things, that when you're wanting to have a will and you're saying such and such gets these certain things, are I want them to have my real property, but that real property was purchased during the marriage, and your spouse was purchased during the marriage and nobody ever transferred interest to one spouse, then that other spouse still owns a part of that. So you can only give away what you own, which will be 50%. And then that other 50% will still be owned by your spouse.
Ms. Hayes,
Yes, ma'am.
let me just come up here because I want to pay on death accounts. I struggle with them. And if any, I don't want to know your business. I don't want to know if you're married, if you got mixed marriage, you got babies, outside kids on. It's why it's so important to have these conversations, because we think because we got married and I'm the wife that I get it all. I don't. If you have kids from other relationships, everything just doesn't go automatic to the wife. But you talked about a pay on death account. I usually discourage pay on death accounts because When you do a pay on death account, that money goes directly to you, right? And it is income that's taxable. What's preferable is joint tenancy with right of survivorship, JTWROS, joint tenancy with right of survivorship. So you go to the bank, you sit down with the teller, they give you your signature card, and then you designate whether or not you want a joint tenancy with right of survivorship, pay on death, or you can be a co-signer on the account. If you're a co-signer on the account, that's not the same as co-owner. All right, and my example that I give is mine and my brother and I. I'm my mother's favorite child. He's not here, so he can't say, you don't ask people. But, so what happens is, my brother is a co-signer. If I'm out of town, or if something happens to my mother, he can co-sign on that account and pay bills. If my mother's in the hospital, if she's doing it, if something happened, he can co-sign on that account. But if something happened to her, he is not a co-owner of the account. You can be married and have separate accounts, because that's my plan. If I ever had a husband, he ain't got nothing. So on my account, I'll have my name, and I may have Russell be a co-signer because I trust Russell, right? I may have him be a co-signer, and I may have a joint tenancy with right of survivorship with him. It doesn't matter if I am married, because that account is in my name. The bank is not going to do a divorce.
Right.
They're not going to determine community property. If it's pay on death, it's just pay on death, whoever owns that account. But if you have two names, and me and Russell both name on that account, and we co-share, then the bank on the pay on death still doesn't know how to divide the money, and you still gonna need a will or something to tell the bank how to move that money. And so now I'm gonna let you close out with an heirship, because I don't think we talked about the people who not gonna listen to us today, and they gonna die here and go to glory and not have a will, and they stuff still gonna be sitting over there in Rodney.
Thank you. So the other thing, if you don't have, so again, the importance of a will is to tell people what you want your wishes to be, who you want to give what, and in what amount and all of that, if you decide to make that that distinction. But so let's say you die without a will, which is not, it's difficult to, that process is a little bit more expensive and it's more complicated because you may not be able to locate certain people. And then it doesn't go according to how you want it to go. It goes according to the laws of the state of Texas. And so let's say you're married and you don't have a will, and if all your children are of that marriage, it will go all to your spouse. But let's say you have children that are outside of that marriage, then at that point, you're going to be sharing assets of that deceased person with their children. And that can create some complications and some frustrations, because you can't force them, let's say if there's real property involved, you can't force a person to sell. You can't force a person to stay either. So it can get, that's why I see a lot of issues when people are like, I don't have a will, but I have real property, now I have to share it with his kids, and now I want to sell the property, but they want to keep it, and now you have this struggle. So, so depending on your circumstances, it's going to kind of vary who will get what. But if you don't have a will, you'll have to go to court and do what's called, ask the court to determine who the heirs are. So it's called a determination of heirship. So you're asking them to say, these people that we put in this application, we want you to verify that these are actually their heirs, and this is the assets that they have, and this is who gets what. The process can be a little bit longer, and it can get expensive because the court is going to appoint, because the court is not going to just they're going to see your application, they're not going to take it just as valid immediately. They're going to appoint what's called an attorney ad litem. That attorney ad litem, it costs a fee for them as well, and they're going to do an investigation to determine whether the application is valid, and you're going to provide some witnesses for them to interview to determine whether the information is in fact correct. So that's kind of the process to do determination of heirship if you don't have a will. And there's some other things like a small estate affidavit. If your estate is less than $75,000 and your debts don't exceed the value of your estate, then you could do a small estate affidavit. But all of the heirs will have to sign off on that document. And then you can submit that to the court. And that's a quicker process. It's much easier, but it can be difficult if you don't have all of the heirs. Yes, ma'am.
I have a question. Now, from my understanding, wills are for people that's older in age. I really don't have nothing, but I have 3 kids, so can I get a will and add stuff as I go?
So yes. Wait, did you finish your question?
No, that was it.
Okay, so you can't, now you can do what's called a codicil. You can add, like, it's like an amendment to your will.
Okay.
I personally just tell people just do your will over, because then trying to keep up with all those documents, you may not.
All right.
And then so, and you want to kind of keep it updated I tell people every 5 years just to review it to see if anything has changed. And if you have minor children, you can actually designate in your will who you want to be a guardian for them.
Okay.
In there. And then, and a lot of people say it is for older people, it's for anybody.
Yeah.
Because,
But see, I'm learning that today because I never was really like, okay, let me go get a will.
Yeah.
Like, that was never important to me.
Yeah.
So.
and a lot of people say, well, I don't have any assets. I
Right.
don't have any money, I don't have anything.
Right.
Well, you never know. And you never know what you're going to inherit. And then you don't know how you're going to come about, how you're going to die. It could
Yeah,
be in a
that's
car,
right.
it could be in a car accident, and then
Yeah.
now you're old you have personal injuries or wrongful death lawsuit, and there's some money that may be owed to your estate, and then you don't have a will to determine who gets those things. So you just never know.
All right, thank you.
You're welcome. Yes.
What it sounds like you're talking about has a lot to do with the legal matters and finances. What happens if a person passes away and you got brothers and sisters and they want to determine how the burial is going to be arranged, where they're going to get buried? Is there legal attachments for that, how you want the funeral, what color flowers? Because I've seen families argue over that. Well, I want mama to be buried in this dress or this and that. Is there any legal something that makes that one person
Yeah,
make
so
all the decisions?
So one, I would always tell people to either, before you die, just if you're doing all your estate plans, get with the funeral home you want to actually do your arrangements and have a contract with them. And then you can also memorialize that in your will to say who your funeral home is and that you already have a contract, just so people will know. And if you want to be cremated and all that, you can put that in the will. Now, of course, the will takes effect at probate, so you can put that in there, but it's not going to be effective yet. And you're just hoping that they know that this is telling them your wishes. But according to the state of Texas, there is an order. So first, your spouse has the right to make all your funeral arrangements. That's the first priority. And then your kids can after that. And then you have like the next of kin and all of that after that. But your spouse goes first, and then your children, and then siblings and things like that.
So there's a document that would say that?
So there's a government code that says that, and I have it on my phone. I can probably give it to you if you need that. But that's the way.
There's also a disposition of remains.
Yes.
Which is a form you can have filled out that will tell the funeral home, the medical examiner, the hospital that has your body, who is responsible for how your remains will be disposed.
Yes. Disposition of remains.
I'm seriously, I'm not gonna say nothing.
No, that was important, Judge. Thank you.
Grab that mic if you do.
I do, but I will not.
No, that was good. And then you have a question too?
Yes, ma'am. Where should the will be kept for everybody, like the siblings, if you have a spouse, you know?
That is a great question. So I tell people, and I've just started kind of advising, because so many people lose their wills, and I've had to probate a couple lost wills, and that could be a difficult process, a little more complicated, not necessarily difficult, because you can probate a copy, and I always keep a copy of all my clients' wills, and then I give them 2 copies just to give to the executor and for them to keep. And sometimes if they want to keep them, I don't ever keep an original. I tell them first, you may want to go ahead and file it in the county clerks where you live.
Okay.
Because they can safeguard it, and they'll give you a certificate of deposit. And that deposit will give you it'll act like a cause number on there to give you the name and all of that, and that you have deposited the original will. The only person that can remove that will is you and the attorney that drafted the will, and the attorney that's hired for the probate at that time. And then all you do is you do the application for probate when that person passes, and you just reference that certificate that you deposited with. That's one way. I say that's the first one. And then the second one is if you trust that executor, now you gotta trust that executor, you can, if you have a safe deposit box, you can keep it there. If they need a key, and they need access to that safe deposit box. Without access, then they're out of luck, and they're still gonna have to go to probate court to get access to their safe deposit box. If you don't have that, wherever you keep your important documents in like a safe at home that has a lock on it and it's fireproof, then that's okay. I I still advise it's the first thing to be in the probate courts.
So you can file a will prior to death.
You deposit, well, not file, you deposit for them to safeguard it for you. So it's like filing, but I would rather think of it as a deposit, so they hold it for you.
And just as recent as Thursday, I'm part of my sister's estate, which they're just acting crazy. People go crazy when people die.
Even if it's just pennies.
Even if you have nothing, you know, they go crazy. I had to testify as a witness of who her children were. And my sister had to testify who her children were because her husband is deceased now, and he had children on the other side. So now we got two sets of children fighting for this one little house.
Yeah.
And everybody's saying, well, that's not his son. Well, he was his son. You may not have acknowledged it, but he did and she did, and therefore, and he did not carry his name. So it's a lot of mess if you don't have a will, even if you have nothing. You know?
And really quickly, and I'll let you guys go to the next person. That's another thing too, when you're probating an estate and you don't have a will and it's a man, you have to actually prove paternity for that. And that is sometimes difficult to do because you have to do DNA testing. And it's just for men. For women, it's a presumption. But for a father, there's no presumption that that's the case. And you have to either provide, and the birth certificate won't work, and unless they did an actual a statement that they signed acknowledging paternity, that will work. Or if they're on child support, you did some type of paternity, you were in the paternity court and things like that, then that could work. But if you don't have any of that, you're going to have to get some DNA testing done to prove that you're the actual child. So it can get complicated. Just get a will. Just get a will. But that's it. Thank you.
Thank you.